Welcome to Limits Exhausted, Texas's Personal Injury Litigation Podcast.
Welcome back to Limits Exhausted, Texas Injury Litigation Podcast with attorney Kiernan McAlpine, founder of the McAlpine Law Firm and a board-certified specialist in personal injury trial law by the Texas Board of Legal Specialization. Kiernan has tried more than 40 cases to verdict and is frequently brought in by other attorneys to handle complex, high-exposure litigation involving 18-wheelers, catastrophic injuries, and wrongful death. I'm Shamika Rhymes, and today we're talking about what actually happens after a deposition in a serious injury case once the testimony is on record and the case starts to shift. Welcome back, Kiernan.
Good to be here, Shamika. How's it going?
Great, good to see you. Well, Kiernan, after a key deposition concludes, what are you listening for immediately that tells you whether the case just got stronger or more complicated?
So depositions are the most important part of discovery in most cases. And it's Depo 101, Depo being the abbreviated lawyer jargon for deposition. It's Depo 101 that you don't win your case in a deposition. What a plaintiff can do to help themselves improve their case during their deposition is just be courteous, pleasant, and make a good impression on the defense lawyer. The best case scenario in a deposition is that nothing changes, that the plaintiff gives testimony that's consistent with the documents, the pleadings, and discovery responses in the case, and there isn't anything new. That's ideal. Facts don't really get stronger during a deposition, but they can get more complicated. So the reason why depositions are so important to lawyers in terms of evaluating their cases and preparing for trial is that once a witness gives a statement under oath, that witness is stuck with that statement at trial. They're going to have to give the same testimony at trial, and if they don't, then somebody's going to impeach them with their deposition transcript, and that's going to be a real big credibility issue for the jury. So depos solidify trial testimony. They tell lawyers what witnesses are going to have to say at trial. And that's very valuable as a preparation tool and, to evaluate cases.
Well, how often does, now I'm going to say it, depo testimony quietly change the defense's posture, even when nothing dramatic happens on the record?
Absolutely. So nothing dramatic happening on the record by itself is probably going to be a bit of a cautionary tale to the defense lawyer, because whatever they hope to get out of the deposition, they didn't get. And what's really, I think, important to remember is that when I'm taking a deposition of an adverse witness or a party, somebody that I sued, chances are I've never seen that person before. I've never talked to him before. I might have an idea in my mind about who they are or how they'll come across, but you don't know until you talk to them and actually do the deposition. So the deposition is a reality check for the lawyer on who the witness is. And it's the lawyer's chance to see the witness through the eyes of the jury and kind of imagine how they'll be received by a jury. For example, like my goal is always to get a defendant to confess that they were in the wrong, or if they won't, commit them to their unreasonable story, show how careless their attitude is, and make them look like a menace to society, right? Defense lawyers have their own goals, and the depo's a reality check on how well these framings will stick in front of a jury. So what will change quietly behind the scenes is the lawyer's impression of who the person is and how they're likely to be received by a jury.
What parts of a deposition tend to matter most later on, even if they didn't seem significant in the moment?
A couple of things come to mind. First would be like maybe the biggest area of potential problems is the personal background section of the plaintiff's deposition. I could probably do a whole podcast about why this is true, but those are areas where witnesses can sometimes struggle with the questions. And additionally, another really important area that will matter would be testimony about how the plaintiff feels right now in terms of their injuries and physical capabilities and mental health. and what their attitude is towards having more treatment or towards treatment they've been recommended for that they haven't done yet. And so those answers that they give will really matter, right? Um, Another
Hmm.
thing that I think is super important is that if the defense lawyer is asking a plaintiff about, tell me about how your injuries changed your life. What can you not do anymore? What can you do but can't do as much? Those questions, I always encourage my clients to go into full gory detail on those questions during the deposition, right? Which is not intuitive for a plaintiff to do because they're the victim. The defense
Hmm.
lawyer is not a sympathetic ear, even if they come across pretty nice, which they don't always do, but a fair amount of the time they do. But even when they do, I think the plaintiff instinctually knows this person is not a sympathetic ear. They're not here to help me. And sometimes they can be pretty light-lipped in how they answer questions about how these things are affecting them. And, it's very important that they go into gory detail because if they give a short answer in a deposition and then they give, a really lengthy, um, heartfelt account of it at trial, defense lawyer is going to ask, well, I asked you the same question in the deposition. How come you didn't tell me all that? So we really want to
Yeah.
have our clients give complete answers to those questions in the deposition.
Well, how do inconsistencies or concessions made in deposition testimony typically resurface during motion practice or expert discovery?
Sure. So, I mean, one thing it's important for a lawyer to know before they go into a deposition is what they're trying to get out of it and what the table stakes are and what needs to happen. And for example, in premises liability cases, we know in a premises liability case in Texas, we're going to face a motion for summary judgment. The defendant is going to ask the court to dismiss the case as a matter of law and end the case without a jury ever seeing it. So, I mean, in those cases, we really need to push for concessions and make progress in terms of the factual record because we know we're going to have to file responses to motions and we know that we're going to need ammunition in those in order to beat a summary judgment. One of the things about depositions that's, typically speaking, what can come back, like what concessions matter. I mean, anything that's bad for the plaintiff's case, right? But we can't just say that to the plaintiff because they don't know, right? Like the clients aren't lawyers. They don't know what helps them. They don't necessarily know what hurts them. And we can't make them accountable for that. So what I always tell clients is just honesty wins. The truth can't hurt you. Like if you give an honest account of what's happened and what you're going through and you just toe the line that way, the truth can't really hurt you. It's very unlikely that anything is going to come back to haunt you in a way that's surprising or upsetting. Um, when it comes to expert witnesses, I mean, experts, um, sometimes testimony will become important in context of expert opinions, but I think we're going to talk about that as well. I can go into that in a little bit more detail if you want.
Yeah, I think we'll bring it up in just a second, actually. But can you walk us through a case where the real impact of a deposition didn't become clear until weeks or months later?
Yeah, I mean, like a lot of the time, the deposition's impact is going to be pretty clear, like relatively quickly after the deposition, or even during the deposition. Like I
Hmm.
recently settled a case not too long ago where, you know, I just took the deposition transcript a couple weeks after the deposition was over, the day that I got it, and I took out key parts of the deposition and I put them in a demand letter and I sent it off to defense counsel and the insurance company. And I said, this deposition completely establishes that you need to pay this demand. And unsurprisingly, a few weeks after that, they settled. So, um, you know, the big stuff generally becomes obvious quickly or sooner rather than later. Um, but in trial, it's always interesting to look back on questions that you could have asked a little bit differently or a witness could have answered a little bit differently.
Well, how do defense teams usually try to contain or reframe damaging deposition testimony once it's locked in?
Well, once it's locked in, it's locked in. I mean, there isn't any real science to it. I mean, they'll use whatever they can think of to try to continue to argue their points. But I mean, a lot of the time, once we have locked in damaging concessions, then they can't contain it. And sooner rather than later, the insurer is going to find their checkbook and the case is going to get resolved. Once you've got sworn testimony that's very favorable to the other side of the case, then there's very little that you can actually do to try to um, mitigate that if it's on an important issue.
Well, what role do deposition transcripts play in shaping those expert opinions, both on liability and damages?
Absolutely. So experts are being paid by the hour generally. Experts are always being paid by one side or the other. And if you send an expert a deposition transcript, even if they're an expert in a technical field that doesn't have that much to do with any witness's testimony per se, they'll read it. Like it's another piece of information that an expert will look at and consider. It may influence
Mhm.
their opinion. It depends on the type of the expert and what they were tasked to do in a case. I will, in a liability dispute case, I will definitely rely on deposition transcripts. I'll make sure that my expert has the deposition transcripts and can kind of address issues. If there's a defensive theory that's being sponsored by a witness, I'll ask the expert what their opinion is about that. And that can be important. One thing that I take a really, really hard line on, though, is I don't allow opposing experts to act like they're able to judge the credibility of a witness. I saw this in a case last month where a orthopedic surgeon was going off about the plaintiff's deposition in his report and commenting on things that he thought made the witness less credible. That's not an orthopedic surgery expert's job. That's the jury's job. Experts don't get to weigh in under the guise of expertise on whether the plaintiff or anybody is someone who should be believed. Like experts are there to give testimony on mixed questions of law and fact and aid the jury in understanding technical issues or scientific issues that the jury would not otherwise have enough familiarity with to assess for themselves. They're there to aid the jury. They're not there to tell the jury what to think about witnesses. So I will really put my foot down on that if I see that.
Well, thank you for that example too. I think that's important to share that. How does deposition testimony influence mediation dynamics, particularly in cases that looked far apart beforehand?
Well, they can really affect mediation dynamics a lot because a lot of the reason why parties are going to be far apart is because they're going to have a different vision of what the case is going to ultimately look like, and depositions are going to kind of compress that space. Like depositions, if a case has had enough of them, kind of kill off the what if game. I think, well, what if
Mhm.
this defense applies? What if that defense applies? What if the evidence says this? Can we argue that? That game starts to die off once we have locked in testimony from the witnesses. Like once they've testified, like once the defendant has testified, know that there wasn't, like slick water on the road, or there wasn't a defective street sign, or my vehicle wasn't defective, or anything like that. Like they can stop kind of inventing possible issues. It really narrows down the factual issues that are in dispute and makes it much easier for the parties to come up with some kind of settlement because we're no longer dealing with a blank slate. Like we're dealing with
Mhm.
known facts that have been established by, admissible testimony. And the record is the record. And so once the record becomes clear on certain points, there's a lot less room for lawyers to try to make arguments, let's say.
Well, once depositions are complete, how do you reassess whether the case is truly trial ready or if it's still missing something critical?
Yeah, so the first depositions that happen in a case are usually of the plaintiff and, one or two critical party witnesses on the defense side. And generally speaking, when the first depositions happen in a case, we're about a third of the way to trial. Like we've filed the case, there's been a scheduling conference, discovery has been answered, all the, back and forth with the emails about getting the deposition set up has been done. and we've got the most important witnesses in the case lined up for deposition. That's usually happening about a third of the way to trial. The last depositions that happen in a case are usually happening right before trial, because typically parties aren't going to depose everybody that they want to depose and incur all that cost and time unless they know they need to try a case. But like once the primary testimony is known, that's generally a good time to evaluate settlement, because we might have 10 witnesses in a case. The party witnesses are 2 or 3 witnesses. Once we've deposed the party witnesses, we can save the time and expense of deposing the other 7 or 8 people, including experts, which are, come with their own costs in addition to the lawyer's times. So, if the depositions of the primary witnesses went well, then that case should settle. And if the case has some lingering issues, if the case still looks tight, or our case is just really a big ask where we're seeking like very significant damages, then the next thing up would typically be expert depositions, and that's kind of another opportunity to revisit things and see what can be done on a case.
Well, as always, Kiernan, this has been such an informative and great conversation.
Thank you so much. I'm glad to hear it.
Thank you. Well, that is it for today's episode of Limits Exhausted, Texas Injury Litigation Podcast. To learn more about attorney Kiernan McAlpine and his work at McAlpine Law Firm, visit McAlpineLaw.com. Thanks for listening, and don't forget to like, leave a review, and share the show so that more attorneys can access these discussions on serious injury litigation.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.